The House did its job. It passed the Save America Act, which will ensure only American citizens decide American elections and that we have a voter ID when we cast our ballot. The House has passed it more than one time, and right now, the United States Senate is sitting on it, and it is going nowhere. Over the holiday weekend, while this country marked 250 years, 3 senators, Mike Lee, Ron Johnson, and Rick Scott, said out loud what a lot of you are already thinking. If the only thing standing between us and proof of citizenship to vote is a Senate rule, then change the rule already. 50 senators are already on the record for the House-backed version of the Save America Act. Susan Collins kept her promise and voted for the House-backed version. So there are 50 votes to pass this bill if it can overcome either cloture or the Byrd rule. 56% of Americans say they want the Senate to keep working and to pass this legislation before the elections this year. The holdup is the 60-vote threshold in the United States Senate and a majority leader, John Thune, who says the votes to change it are not there. Some Senate Republicans are even telling President Trump to move on away from the legislation. But we are not going to move on. Welcome to the Jenny Beth Show. I'm Jenny Beth Martin, and this is The Fight. Only American citizens should decide American elections, and I'll tell you exactly what to do about it in a moment.
Welcome to the Jenny Beth Show.
The Senate math runs straight through the state of Maine, and Maine just got interesting. A woman named Jenny Rascott went on the record to Politico yesterday accusing Democratic Senate nominee Graham Plattner of sexually assaulting her. Plattner calls it categorically false and says he is reflecting on the best move forward. Chuck Schumer, Kirsten Gillibrand, and Elizabeth Warren, among many others, have all told him to withdraw, and the Democrats' own campaign arm says it will not spend a dime on that race if he stays on the ballot. Under Maine law, Democrats can replace Plattner with a new nominee if Plattner drops out by Monday, July 13th. That's 6 days from today. And the Republican in the race is Susan Collins, who said, "These allegations are appalling. Nonetheless, it is not up to me to choose the Democratic nominee for Senate." The same party that says, "No kings, stop fascism, save democracy, believe all women." They backed a Senate candidate with a literal Nazi tattoo whose issues with women were on the record prior to the primary. That party chose this nominee, signaling they are okay with Nazis and do not actually believe all women. The same party that calls itself the No Kings Party is now forcing a democratically chosen nominee to drop out of the race for a hand-picked replacement. It's pure hypocrisy, and it should surprise no one who has watched the radical left closely over the last decade. While all of that plays out at home, President Trump is overseas doing his job. President Trump is at the NATO summit in Ankara, Turkey today and tomorrow, pressing our allies to finally hit 5% on their economy on defense. And NATO is expected to pledge roughly $80 billion in aid to Ukraine. Peace through strength is not a slogan. And there's one more thing I have to bring to your attention before we get to our guest, and this one is heavy. Charlie Kirk, activist, leader, husband, and friend, who was assassinated last September while speaking at Utah Valley University. He had the preliminary hearing for his murder trial is underway in Provo, Utah. It began yesterday and the preliminary hearing is for the man accused of killing him. Tyler Robinson, 23 years old, is charged with aggravated murder. Prosecutors are seeking the death penalty. Erica Kirk, Charlie's wife, was in that courtroom. Charlie's parents were also there. Andrew Colvett from the Charlie Kirk Show was there and gave a full recap of day one on the Charlie Kirk Show. I hope and pray that Charlie's murderer will be brought to justice. And my thoughts and my prayers are with Charlie's family this week as they go through that hearing and in the coming weeks and months as they go through the trial. Now, that brings us to the main topic for today's show. The Supreme Court just closed one of the most consequential terms in a generation: birthright citizenship, women's sports, campaign finance, presidential power. Every one of those cases had the same question: who actually governs America? The people, or through the Constitution, or unelected judges, bureaucrats, and activists? To break it all down, I'm going to bring in one of the finest constitutional minds in our country right after our call to action. Because you know our show is about turning passion into action items. Here's what you can do today. First, call your 2 senators. Remind them they work for you. They're home this week. You can call the Capitol switchboard at 202-224-3121. Ask for each of your senators and tell the senators to pass the Save America Act and to stop hiding between a Senate rule. Only American citizens should be registered to vote in American elections. For talking points, answers to frequently asked questions, and to email your senators directly, go to passthesaveamericaact.com. And second, related to the Save America Act, there's a housing bill moving forward right now, and it can be leveraged to get the Save America Act passed if President Trump vetoes it. Go to whitehouse.gov/contact and send a message to the president. Tell him to veto the housing bill unless and until the Save America Act is added to it. Make it easy to vote and hard to cheat. Joining me now is Dr. John Eastman, one of the country's leading constitutional scholars. John, welcome back to the Jenny Beth Show.
Thanks, Jenny. It's great to be back on your show, and I hope you had a wonderful 4th of July celebration this past weekend.
Thank you, and I hope you did too. Did you get to spend the 4th of July with your family?
I did. My daughter's a violinist, and she was performing with one of the local groups in her community, and they brought about 15 churches together and had all the choirs to make a huge choir of patriotic songs and marched through all of the theme songs for each branch of the military and had everybody in the audience stand up who had been members of that military or had families in it. It was really moving.
Wow, that just sounds absolutely amazing. What a great way to celebrate America 250. So, John, I wanted to get your read on the Supreme Court ruling since last week. Was this really one of the most consequential terms in decades, as I just said, or does everybody just say that every June?
Well, I clerked up there back in the 1990s, and they said that was the most consequential one in decades, and it was at the time. And then we had a lull. Every year more recently, it seems to be consequential, but this kind of hit on all cylinders in a way that even in recent terms we haven't had. We had huge questions about culture wars, the transgendered boys and girls sports. We had a huge important decision overturning a cornerstone of the New Deal in the bureaucratic state case from the 1930s called Humphrey's Executor, restoring the power to the president to control the executive branch. The old theory on independent agencies was they should be free from politics. Well, what that means ultimately is free from the oversight of the sovereign American people. And the court took a major step in restoring the president's authority over the executive branch, which means our authority over the executive branch, because he's the one guy that gets elected. So those things alone made it a very monumental term. And then we get things like birthright citizenship, which we'll talk about at length here in a moment, that kind of goes the other direction on us. But we will continue that fight as well.
So, John, did the court move closer to the Constitution this term or further away?
Well, I think, but for the birthright citizenship case, it moved a lot closer to the Constitution. The important case was called Trump versus Slaughter, that took out the old Humphrey's Executor case, and I can't overstate the importance of this. Back in the New Deal and even before, Woodrow Wilson and the progressives, the whole progressive movement is based on getting rid of the involvement of the American people in how they govern themselves and overturning the Constitution, in place of it putting in the rule of experts, Well, we've just seen with COVID how that didn't work out so well. It turns out the experts don't know any more than the collective wisdom of the American people themselves. And our Constitution was designed to give the American people the final say in how we govern ourselves. And we're celebrating 250th anniversary of our nation's birth. The Declaration of Independence says the legitimate governments are based on consent of governed, not the rule of experts. And so the Supreme Court's decision in Trump versus Slaughter that restores that constitutional separation of powers and accountability is probably one of the most important decisions we've seen in a decade or more.
So, John, which of the
One of
decisions
the
do
other
you go ahead? No, go ahead.
Yeah, I was going to say one of the other things that I think it was important is we've had the tendency recently of lower federal court judges thinking they're policymakers, and because they disagree with the president's policies. And by the way, these were not policies that were hidden in the campaign. All the policies he's implementing were the things that he was front and center in his campaign. And these judges with the most pretextual claims of upholding law are striking down these policy initiatives of the president, basically substituting themselves unelected for the elected president of the United States and the thing that we, the American people, wanted. And so in a couple of the immigration cases, the repeal of temporary protected status, for example, or the notion that if you're going to seek asylum when you arrive in the United States, that you have to actually have arrived in the United States in order to be able to make those claims. These were attempts by the Supreme Court to push back against these judicial policy making by these lower court judges who never got a single vote and were never elected to anything. So I think that's an important pushback against a wayward judiciary as well. So those I think, are the most structurally important cases and massive move back in the direction of constitutional governance.
Which is extremely important, because the closer we are to the Constitution, I think the better off we will be. John, do you think any of those decisions that you just talked about we will still be talking about in 20 years from now? We're going to get to birthright citizenship in a moment, so let's hold on that one. But of the others, are there any that we'll be talking about in the next 20 years from now?
I think Slaughter is going to become one of the linchpins of a restoration of constitutional separation of powers and accountability. I think that'll be in every single constitutional law textbook going forward. There will still be those that try and keep Humphrey's Executor in those books, hoping that it'll get revived. But I just don't see that getting revived. The argument against independent agencies that get to make regulations, which is pass laws legislatively, enforce those regulations, that's an executive power. And many of these agencies have their own administrative law judges that then determine. This is a consolidation of power, the legislative, executive, and judicial powers all into one independent agency, never elected. It would have had James Madison and his philosophical mentor, Montesquieu, turning over in their graves. So I think the Slaughter decision that slaughtered Humphrey's Executor is going to be treated in textbooks and our law schools and our public discourse for generations to come as one of the most important structural decisions the court has ever made. The only thing that kind of weakens it is Chief Justice Roberts tried to split the baby and say that the Fed Reserve Board is different. I think his attempt to exempt the Federal Reserve Board from the constitutional requirements is not going to succeed in the long run, because the argument and the reasoning of the Slaughter case is so powerful and profound that even the Fed has to be accountable to the American people. So I think his attempt to split the baby won't last, but I think the Slaughter decision will be the one that stands in the ring victorious at the end of the day.
As it absolutely should. And what he said about the Fed is very, very frustrating, because right now they're above all law and above checks and balances, which is completely unconstitutional, and that simply cannot stand in the long run.
He got there with a very historical analysis, saying that, we had the first and second national banks, and those were upheld. The first and second national banks were banks. They were not government agencies. They did not exercise executive power. The difference between the Fed, modern Fed, and the First National Bank is not just a difference in degree, it's a difference in kind. And he just glossed over that. So, he's roundly getting criticized for that weak historical comparison. And I think therefore that decision, it's called the Trump versus Cook, won't have, and it was at a preliminary stage in the case. So there's more to come in that case. And I think the Slaughter decision is what will eventually prevail.
Okay, that actually is very, very comforting to understand. It's at a preliminary stage. It still has to make its way through the rest of the court, and it should not prevail. And it seems to me that several of these justices just didn't understand history at all when they were making some of the decisions. All right. Stay with me. We'll be right back. And we're going to talk about the case that everyone is talking about, which is birthright citizenship. We'll be right back. You are the grassroots of America. You love this country. When you love something, really love it, the news doesn't just inform you, it fires you up. And you find yourself asking, how can I make a difference? That is exactly what this show is built to answer. Never, ever, ever, ever give up. We owe it to every American who has ever voted to make America great again. We owe it to our future selves. We owe it to this republic to stand tall, to stay active, and to be smart about how we spend our energy so that we can win. Here on the Jenny Beth Show, we're going to help you do exactly that. Every show, we will break down the news, connect it to first principles, and give you specific, effective ways to take action. Not just outrage, action. And I am so glad you're here on this journey with us to do it. So let's get to it.
Welcome to the Jenny Beth Show.
And we're back with Dr. John Eastman. John, let's get to the heart of the ruling that has upset so many and made others on the other side of the aisle, I guess, very happy. The court ruled 6-3 against President Trump in Trump versus Barbara. Every headline said Trump loses on birthright citizenship. Is that an accurate way to describe what happened?
Well, even the number is wrong. On the key constitutional question, whether the 14th Amendment Citizenship Clause mandates automatic citizenship for the children born to illegal immigrants or temporary visitors, the vote was 5-4. Brett Kavanaugh decided the case on statutory grounds. I think he was wrong about his statutory argument, but he explicitly said the Constitution doesn't compel this result, so Congress can change it by changing the statute. So the main constitutional question was 5-4. Chief Justice Roberts and Justice Barrett joining with the three liberal members of the court to say something that the American people never voted for, never ratified, and that the citizenship clause gives citizenship to people who are here illegally, to people who are here only temporarily. And I think Justice Thomas in his dissent did a workmanlike, thorough job exposing the historical flaws in their reasoning. I did an article published at American Mind that I would encourage people to go read. Chief Justice Roberts says that, the English common law on jus soli, the law of the soil, begins in 1608, and we adopted it when we became a nation. It crossed over the Atlantic, and we adopted it. And my article begins, he started in 1608. I think we should have started in Philadelphia in 1776, because our Declaration of Independence is an absolute repudiation of the English common law rule of jus soli. Under the English feudal doctrine, if you were born on the king's soil, no matter the circumstances, unless you were the child of a diplomat or an invading army, if you were born on the king's soil, you owed the king a perpetual allegiance, and you could never renounce it. Well, look at the last paragraph of the Declaration of Independence. It says, we declare that these united colonies are and of right ought to be free and independent states, and we hereby absolve all allegiance to the British Crown. I mean, that's just an eloquent repudiation of the doctrine that Chief Justice Roberts claims crossed the Atlantic unchanged with the American Revolution. And so I think, particularly ironic that in the very week we're celebrating our 250th birthday, and honoring that Declaration of Independence. He completely overlooks it. So I think we're going to see a lot more commentary, a lot more action by our elected officials in Congress and state legislatures. We may even see a unique convention of the states call to fix this one particular problem, because quite frankly, the notion of birth tourism and being overrun with millions and millions of illegal immigrants producing citizens without our consent, it's not just dangerous for the country, but it takes out the cornerstone principle of consent of the governed that is in the Declaration of Independence. It's a radical transformation of our country's history and underlying principles.
John, I think that we have the right article up from American Mind. I just searched for it very quickly, and my producer has it up on the screen. It's pretty easy to find if you just search for American Mind, John Eastman, and then we'll include it in links to the show post-production.
Yeah.
The
Jenny Beth, that's the article I did the week before on the immigration cases.
Okay.
This one's called 1608. 1776, not 1608.
Oh, I see it. So I got the one up for American Mind, 1776, not 1608, what the Supreme Court got wrong on birthright citizenship. And then we'll show another one in a minute from American Greatness that you wrote, universal human equality does not require universal citizenship. John, how did we get to this point where the court could be so wrong on this particular issue? What is the history that led to us even being in the court over this?
Well, I think almost uniformly the views by those that drafted and ratified the 14th Amendment, they were codifying the 1866 Civil Rights Act, which even more clearly said all persons born here and not subject to any foreign power are citizens. So, of course, if you're temporarily visiting here, you remain subject to the foreign power of your home country. And Native Americans who were born on U.S. soil but owed their primary allegiance to their tribes were explicitly said not to be getting automatic citizenship under the 14th Amendment. And that was the early treatise writers. That was the early Supreme Court. After the 14th Amendment was ratified, everybody understood that. Early secretaries of state denied passports or citizenship status to children born here of Irish or Scottish or German temporary visitors because their parents still owed allegiance to their home country, and the children followed that allegiance. It wasn't until 1898 in a case called Wong Kim Ark, where there were some Chinese parents who were permanently and lawfully domiciled here, and the child was born here, and the court said that child is a citizen. But 28 times in the opinion, it referred to the fact that the parents were lawfully domiciled here. That meant permanently here with our consent. It did not mean that they were temporary visitors, and it certainly did not mean that they were here illegally. But there was broad language in the opinion saying we've essentially adopted the old English feudal rule of jus soli, the law of the soil, when in fact we never did. But over the century and a quarter since that decision, it kind of took root, not immediately, but by the mid of the last century, people in government were acting as though anybody born here, no matter their circumstances, were citizens. And that false understanding or misunderstanding, took root. But I think what's been most encouraging and exciting about this case is how most people thought the issue had been settled a long time ago, and they're now realizing that it was never settled. And to the extent that the court thinks it's settled now, they got it wrong, and people are speaking up against it because they recognize how important it is for a political community to be able to define the scope of its own political community, who are citizens and who are not. And if you're a country grounded in the consent of the governed, that's a two-way street. It requires bilateral consent. So imagine if Congress said tomorrow that everybody in Mexico City is a United States citizen, and we're going to start taxing you as United States citizens. The folks in Mexico City might say, hey, we haven't consented to that. We're not part of your political community. We reject your offer of citizenship. Well, the flip side of the coin is also true. You can't just come here and lay claim to citizenship by violating our laws to get here, and therefore without our consent, and lay claim to citizenship when the country is based on consent of the governed. So this fundamental principle just seems so clear to me, and it's surprising to me that very smart people on the court didn't seem to get it.
It is surprising, and at the same time, I suppose not surprising. One thing that frustrates me, John, is that last week or two of June roll around, and it seems like every year we're just sitting around anxiously waiting, sort of like you're waiting for Powerball in a lottery, and you have no idea how it's going to turn out, and you really feel as if your life is up to some sort of random chance, just waiting for the numbers to fall where they may, to determine how we're going to be living in America. And it just seems very, I don't think our founders ever intended for the court to have that kind of an impact. I don't know that it's working exactly the way that it was supposed to originally, but there are cases, as we talked about a minute ago, that did bring us back closer to the Constitution, and that is a good thing. And what you just said about how everyone thought it was settled law, but now they realize it never was settled in the first place. Explain to us how what can we do next if they made a bad decision? So how do we deal with this? Are we going to be stuck with it for 125 years now, or do you think we'll be able to correct it earlier?
Well, I mean, the decision stands for now, but I think in our system of government, if it's going to stand forevermore, to quote Abraham Lincoln, we will have ceased to be our own rulers to that extent. And so the third article I've written about this case is published at the Federalist, and it takes up the issue the Supreme Court has ruled, what now? And I encourage Congress to take up Justice Kavanaugh's invitation to address this with statutes. Now, technically, the Supreme Court has made a constitutional ruling, and Congress cannot change it by mere statute. But in that article at the Federalist, I remind people that when the Dred Scott decision came down, one of the most horrendous decisions the Supreme Court ever issued, and it specifically held that Congress had no authority to prevent slavery in the territories. A few years later, Congress passed a statute preventing territory in the slaveries, pushing back against the erroneous decision in Dred Scott. And I think Congress should do something like similar now, to let the court know they disagree, that they think the decision is incorrect, that it's harmful to our body politic, and they're going to exercise the powers that they have under Article 1 to try and do something about it. That will force a further debate among the American people about this, and either the Supreme Court changes gears or the American people adopt a constitutional amendment to correct what I consider to be a very damaging error. To use Justice Alito's language in dissent, he thinks it's one of the most profound and profoundly wrong decisions in our American history, and I think he's right about that.
Talk a little bit more about the dissent that Alito and Clarence Thomas had, the dissents, I suppose, because they both wrote dissents.
Justice Thomas is I think it's a 91-page dissent, and he just marches through the historical record and the evidence. And I have to say, I've been working on this issue for nearly a quarter century. Several of my colleagues at the Claremont Institute have been at the forefront of reminding people what the original understanding of the Citizenship Clause was. People like Ed Earler and Thomas West and Mike Anton. But I have to give credit to the Solicitor General's office in this whole case. I mean, their briefing and the historical research that they've done in their briefing, and John Sauer's oral argument, was just spectacular. And what Justice Thomas does in his 91-page opinion is just march through that language, that historical record, the principles underlying it about the Declaration of Independence that I just spoke about earlier. And then Justice Alito comes at it from a different angle, but makes many of the same points. That the notion that this government, a Republican government, based on consent of the governed, has adopted an old English rule of subjectship, where you are subject to the king because you're less than the king. It just violates every principle of our Declaration of Independence. And so those two dissenting opinions are just profoundly important. And we often see powerful dissents carry the day in the fullness of time. When I'm talking about the Slaughter decision earlier, overturning Humphrey's executor, you go back to the 1980s, and there was a case that followed suit, expanded Humphrey's executor to special prosecutors. Morrison versus Olson was the case. And Justice Scalia was a lone dissenter in that case. And yet his opinion and reasoning were so powerful that it eventually carried the day. And I think we're going to see something similar play out here with Justice Thomas and Justice Alito's dissents as well.
John, do you, based on the fact that Clarence Thomas went into such deep history and paid attention to what the Solicitor General wrote, how did these other justices get so wrong? And how could they have thought that the Old English rule where a citizen is subject of the king be okay, especially as we're going into our 250th anniversary revolting against a king?
Well, the legal academy, which means the leftist legal academy, we should be honest about that, was overwhelmingly saying this was decided 125 years ago, and you have no business changing the rule. And I think a couple members of the court think that even if the decision is wrong, sticking with an old rule, even though it really wasn't the old rule, is important to protect the integrity of the court. I hope that's not what was going on, but one gets the sense sometimes of that. Look, the fact of the matter is, most scholars had acknowledged that the precedent of Wong Kim Ark did not settle the question for temporary visitors or illegal immigrants. That was in dicta. Now, when President Trump came down the escalator in 2015 and made this one of his planks in his 2016 campaign, many of them started changing their tunes and saying for the first time that this had been settled over a century ago, when in fact it had not been. But I think our own government had started acting, maybe by the mid 1960s or so, as if it had been settled, and anybody born here, no matter what, were treated as citizens. Bureaucrats ignoring the long history that Justice Thomas elaborates on in his dissent. And so one of the most significant parts of the president's executive order, I think, was to acknowledge that a lot of people had probably come to rely on that erroneous understanding of the citizenship clause. And so the president made his executive order prospective only. We weren't going to go back and pull the rug out from under people that had been told that they were citizens. But going forward, we were going to fix this not insignificant problem, dealing with our nation's sovereignty and our ability to decide for ourselves who are parts of the political community. And this is the third article I wrote. Justice Jackson's concurring opinion, and this is the piece I published in American Greatness. She said the Declaration says all men are created equal, and that means everybody is entitled to universal citizenship. Hogwash. It means nothing of the kind. I mean, if you look at the first paragraph of the Declaration of Independence, when in the course of human events it becomes necessary for one people to separate themselves from another people, then they have the right to do so. Then it goes into the Universal Declaration of Human Equality. We are all equally human beings capable of governing ourselves. But how we govern ourselves is always in particular political communities that we decide as that political community based on our consent. So the two are not mutually exclusive like Justice Jackson thought they were. And again, it's another category error in the opinions that led to this decision that I think will not stand the fullness of time and will eventually be repudiated either by the court itself, acting under constant bills coming out of Congress saying you got it wrong, or the American people standing up and saying this is just not right. We have a say in who our political community is, and we're not going to give that up. It's part of our inalienable human rights.
Yes, and I think that
what I would have liked to have seen is somebody asked.
Go ahead.
What I'd like to have seen is somebody ask the question: do you think that anybody that voted to ratify the 14th Amendment intended to confer automatic citizenship on people who had to come to this country illegally? And if the answer to that is no, of course not, then where have we consented to giving that automatic citizenship? The fact of the matter is we haven't.
And I think the same thing could be said for, did they intend for citizenship to we did not even have airplanes. So the thought of being able to come into our country and to arrive here in a matter of hours, have a baby, and then turn around and leave if you wanted to a couple of days later or a month later, it wasn't even conceivable because we didn't have the kind of travel that we have today. So they also could not imagine the tourism citizenship industry that is going on right now. And it makes no sense to me. Their decision, it just seems to ignore the Constitution, and it ignores common sense as well.
Yeah, the British themselves got rid of their English common law rule because it makes no sense modernly. I mean, look, what we're dealing with birth tourism is that our major political enemy on the world stage, China, is producing hundreds of thousands of American citizens who can come and move about our country at will. The number of military age young men who had become citizens by birth tourism is now an army that can come within our shores whenever they want. The notion that this isn't raising serious national security problems is just naive beyond measure.
It seems like we just lost John Eastman. We're going to try to bring him back in while my team is working on that behind the scenes. Let me go back through the call to action for you, which is we are working on the Save America Act. And right now, there are two different angles for calls to action this week. The first continues to be putting pressure on the United States Senate. So calling both of your United States senators, you can call 202-224-3121. Again, 202-224-3121. And ask for each of your United States senators, call and tell them to pass the Save America Act. Tell them that you're tired of the excuses and you want them to find a way to get it done. And I really think it is important that you're calling Democrat senators and Republican senators. So even if you have a Democrat senator, don't let that be an excuse that you're not calling and you're not putting the pressure there, because part of what we are being told is that we cannot get 60 votes to pass this common sense piece of legislation that over 80% of American citizens support. So call the Democrat senators as well. Then we've got an opportunity with some leverage right now with the housing bill. The housing bill passed both chambers, both the Senate and the House, and it's on President Trump's desk right now. We have until July 10th for him to veto that bill. What I urge you to do is to make contact with the president's office and ask him to veto the housing bill unless and until the Save America Act is added to it. You can go to whitehouse.gov/contact, whitehouse.gov/contact to leave that message. And then you can go out to Truth Social and tag the president on Truth Social in order to make that call to action and to tag President Trump on it. And then we have another call to action that I want to go through. And if my producer can get me to 7C, we'll go through this. And it is the Office of Budget and Management has proposed a new rule to end diversity, equity, and inclusion mandates in federal grant making. For years, if you wanted a federal grant for a road, for research, or for the community, you were expected to check ideological boxes that had nothing to do with the actual purpose Congress approved. This rule says that the rule says award the money on merit, on qualifications, and on whether you can do the job Congress authorized the money to be spent to do. It's the rule of law, and that's what we should be doing. There is a public comment period right now for this new regulation that the Office of Budget and Management has proposed. So we need you to help us. What you can do is go to our website, sign the letter supporting the rule, and then we will submit that letter on Friday or Monday. The comment period ends on Monday. So sometime over the weekend, we'll get all of the comments or all the signatures to our comment and submit it to regulation.gov. You can find this by going to TPP, like Tea Party Patriots, .me, M-E, TPP.me /OMB comment. OMB, like Office Management Budget comment. OMB comment. And so go to that website, sign on with our letter, and then after you sign on with our letter, you will have the option to write your own comment for regulation.gov, and you're welcome to do that as well. But if you don't want to write your own comment, you can just sign on to our letter and we will submit your name. Taxpayer dollars should be used for the mission Congress approved, not for an agenda that bureaucrats prefer. So now we've got John Eastman back on with us, and I am going to ask him if he could. Okay, we're going to take a quick break, and then we're going to come back, and we should have John Eastman with us. Okay, and we should have John Eastman back. Thanks for bearing with us. Every once in a while, we just have technical issues. It's the nature of the beast, especially when we're doing a live show. So, John, thanks so much for being back with us. And you were talking about the courts, and I don't remember the exact last thing that you said.
Yeah, I think one of the more important things is even though we've come to view the Supreme Court as supreme, as judicial supremacy rather than merely judicial review, that when they speak in a single case, they've set the policy forevermore. Abraham Lincoln famously rejected that in his first inaugural address. He conceded that the case in Dred Scott was binding on the parties to the case. But he said if we are to accept the court's ruling on a contested matter forevermore, then we will have ceased to that extent to be our own rulers. And they pushed back against it. Congress passed a law directly contrary to the holding in Dred Scott. They pushed back, and it took a civil war as well. Well, hopefully we resolve this issue much shy of that. But the fact of the matter is each of the three branches of government have a say in the Constitution, and the court is the final say on any individual case. But if we're to take that as gospel truth, immovable forevermore, we will have ceased to that extent to be our own rulers. And in our own history, look, I mean, the court made an egregiously wrong decision in Plessy versus Ferguson, where they upheld separate but equal. And, Thurgood Marshall pushed back against that decision for decades and finally prevailed in Brown versus Board of Education. So, the American people have an opportunity here to speak their views on what the nature of our political community is and who decides who becomes members of it. And they should not take this as settling the matter forevermore, but as the beginning salvo in an ongoing conversation about the meaning of our Constitution.
I think that's very important. And perhaps if Congress passes a law about this, if they want to say that if you are here lawfully and you are a permanent resident and you are intent on becoming a citizen of America when the time allows you to, then you have your children have citizenship. I think most Americans probably would fall in the category of saying, okay, that's okay. And there may be some who are listening to this right now going, no, absolutely not. I'm just pointing out that I think that that's probably, if we did polling, where most Americans would land. I think that most Americans would think that it does not make a single bit of sense that a person could have a child here by visiting the country for a few hours or a few days, take the child back to another country and raise the child as if they are a citizen of another country, and somehow that child also is a United States citizen. I think that Americans would have a bit of issue with that, as well as if you're here illegally and you didn't respect our rules enough to follow them upon entering the country, the citizenship happens to the children you have here. I think that there would be a problem with that. So my point is, perhaps if the Congress goes back and passes a new law that can wind up, which would wind up triggering additional court cases, they add that first paragraph in the Declaration of Independence, reminding the court that in the course of human events, it does become necessary to dissolve political bands that have connected you to other people. I mean, if they're saying that this is what it was supposed to be, then maybe when they write a bill, they should just add that to it so that when it goes to the court, they're making it very clear that we're leaning on our founding principles as we write such a law.
And the court's reaction to such a bill is going to be very telling. And there would be two reactions to it. One would be, we have spoken from on high. How dare you, try and push back? That would be the wrong reaction. That would be born out of arrogance and a view of judicial supremacy that the founders never envisioned. Or they could say, we hear you. We think you've got a very considered argument that our decision was wrong. So we are going to reconsider it fully in view of your now considered view as well. And at that point, they could either reaffirm their existing decision or reverse their decision. But at least they would be engaging in the back and forth about the meaning of the Constitution that I think our framers envisioned, rather than speaking out of arrogance. We've spoken from on high. How dare you to challenge us?
Yeah. So I don't know what will happen with it. I don't think that we're going to have a law from this Congress, certainly not in this before November.
We can't even get the SAVE Act out of this Congress. So
yeah, it's just crazy that we can't even get that. But perhaps we will see it in another. Here's what I know that can give us some hope. 10 years ago, well, I guess it was 11, it may have been 2015 instead of 2016, President Trump went down that escalator for the very first time. And in the speech, when he announced his presidency, he talked about needing to deal with the illegal immigration problem that was going on in our country and securing our border. And at the time, people scoffed at it. They didn't think that the American will was there. The will of the American people was where President Trump was. And I think that in 2015, if we had done polling, most Americans probably were not thinking, they were probably thinking secure the border. They may not have been thinking deport everyone who is here illegally. But 10 years later, just a decade later, President Trump and his leadership and showing what can happen. I guess it took Biden showing what awful things can happen when you have a completely wide open border. And then President Trump sealing the border has shown that, yes, now people want those who entered the country illegally to be deported. The majority of Americans do, and that is reflected in polling. And I think that my point here is that we can have relief. It may not happen right away with this Congress, but with the right kind of leadership and a focus on the issue, we can make a difference. It's going to take time. But our founders also designed the system to create slow change. So we just have to understand it does take time.
Well, and I think President Trump had a very important line early in his second term when they shut down the border almost overnight. It didn't take new laws. It just took a willingness to enforce the ones we already have. And that was profound, and it was correct. And, One of the things that's interesting, remember Kamala Harris was made the border czar in the Biden administration, and her view was we need to help these countries that are so impoverished that people see an only option as coming to the United States. I agree with that. We've got a lot of people who have been here in this country illegally. They've gained American skills and an appreciation of American capitalism. I think they should be repatriated to their countries and help make their countries so strong that people don't need to leave and try and illegally immigrate to this United States. So the repatriation of people that have learned a bit of American freedom and American free enterprise, take it back to their home countries and fix those countries so that the whole world's ships rise all together.
Okay, John, let's shift gears very quickly to a few of the other decisions that the court had. The court said that they protected girls' sports. They said biological boys have to be out of girls' sports. And that was a 6-3 decision. Do you think that one is finally settled for us?
Well, the next case that will come up, so that what they said is it's okay for states to prohibit biological boys from being in girls' sports. The next question will whether the girls have a right to exclude biological boys so that the states must exclude them. And that case will come up here in the next year or two, I think, pretty quickly. And I think, look, the whole regime of Title IX that was designed to enhance and protect women's sports is being undermined by the notion that men can participate in those sports. I mean, high school girls are losing out on college scholarships because of this ridiculous woke trend of letting males participate in the girls' sports. And so I think we're going to see that issue come to the forefront relatively quickly. But I do think it's settled because it's so common sense that the notion that states can't take the step of prohibiting boys from participating in women's sports, I think that's pretty well settled. Even the left is kind of backed away from pushing that issue at the moment.
That is very good because it was just a crazy issue, and I hope that we are past that and we're done with it. If not, we'll just keep fighting it and keep standing up for common sense. John, after a term like this, we have some real wins and we have a hard loss. Are you encouraged or discouraged by where the court is currently headed?
Generally encouraged. I mean, I've long been on a mission to recover basic constitutional principles. My litigation center that I founded over 25 years ago, its mission is to restore the principles of the American founding to their rightful and preeminent authority in our national life. And I do that through the courts and through over 200 cases I've been involved with at the Supreme Court. And they're generally coming our way. If I go back and look 15 years ago at my goals, I've won about 75% of them already. So we're getting there. A couple of losses on the way, but
Okay, I think we are not going to be able to get that last question answer from John Eastman, and we're just having too many technical difficulties. So I appreciate John Eastman being on today, and he really has helped us explain what was going on with the Birthright Citizenship case. He's such a brilliant mind. I wish the connection had been a little bit better, but we'll just make sure that we work on that the next time. Again, for our calls to action, we've got the Save America Act. So make sure you are calling both of your senators, urging them to vote for the Save America Act. You can call 202-224-3121. Again, 202-224-3121 and call, ask to speak to both of your senators. Tell them to vote for the Save America Act. You don't want excuses. You want them to find a way to get the bill passed. If they need to negotiate with their fellow colleagues, with their other senators to make changes to the bill in order to get it passed, make changes to the bill. If you need to add it to NDAA or FISA, or if the president vetoes the housing bill, you add it to that. Whatever it takes, reconciliation, whatever it takes, find a way to get it done. The American people deserve to know that only American citizens are voting in our elections. Also, reach out to the White House, urge President Trump to veto the housing bill unless and until the Save America Act is added to it. You can do that by going to whitehouse.gov/contact. And then for that last issue, one more time about the Office of Budget and Management, it has proposed a new rule to end diversity, equity, and inclusion mandates in federal grant making. For years, if you wanted to get a grant for a road, for research, for your community, you were expected to check ideological boxes that had nothing to do with the actual purpose Congress approved the money to be used. The new rule says that the money must be awarded on merit, on qualifications, and on whether you can do the job that Congress authorized. It's pretty simple, and we should only be funding things as Congress authorized them, not for ideological purposes. The comment period for this proposed regulation is open right now through next Monday, and your voice counts. So what I want you to do is go to tpp.me, like Tea Party Patriots.me/OMB comment. O as in office, M as in management, B as in budget, comment, OMB comment. And sign our letter, which will say merit, not ideology, taxpayer dollars for the mission Congress approved, not for the agenda bureaucrats prefer. And after you sign our letter, you'll be given an option to leave your own comment at regulation.gov. You're welcome to do that, or you can just sign on to the one that we're generating, and we'll submit your name next week when we enter our comments at regulation.gov. And I want to leave you where we left last weekend. 250 years. On the 4th of July, the sky over Washington lit up unlike anything we have ever seen before. And President Trump stood up and reminded us of what this country is and what it cost to build it. Benjamin Franklin was asked what kind of government the Constitutional Congress gave us. And he famously said, a republic if you can keep it. That's the whole ball game. This republic is ours as long as we are willing to keep it. It means being eternally vigilant, not someday, not next week, not next month, but today and every day. Today is the best day to pick up and do the work it takes to keep our republic. If you missed our Constitution and Founding Principles training that we launched yesterday, go watch it. The link is at teapartypatriots.org/1776, and it's on your screen right now, especially if you're watching YouTube, you can just click through. Next Friday, the next episode of this training airs, and we'll be airing it every Friday for the next 2 months. It's how we keep our republic, keeping one citizen, making sure one citizen at a time understands and appreciates our founding principles. Only American citizens should decide American elections, and we should show a voter ID to cast our ballot. Go make those phone calls, and God bless you. God bless the United States of America. I'm Jenny Beth Martin, and this is the Jenny Beth Show. If you enjoyed today's conversation, go ahead and hit like and subscribe. It really helps us reach more people who care about liberty and the Constitution. You can find this and other episodes at jennybethshow.com, as well as Facebook, YouTube, Rumble, Instagram, X, and your favorite podcast platform.
The Jenny Beth Show is hosted by Jenny Beth Martin. The Jenny Beth Show is a production of Tea Party Patriots Action. For more information, visit teapartypatriots.org.